What do you think? He was emotionally devastated by this. He spent a year in psychotherapy. I'm making this up. Let's assume that he was emotionally devastated. Went to the shrink, paid the shrink a ton of money, suffered emotionally for a year or so. But the statement that wounded him so much turns out to be privileged as a fair and true report in a public journal of something that happened in court. What does that mean? It means he gets nothing. He loses because the statement was privileged. No. Okay, well, enough mystery stuff. Let's look at now we get to the truth and what the elements of a libel case are, and let's take them one by one. Some of this stuff is so obvious that you wouldn't think about it, like that the statement is published. It has to be published. And in the law of defamation, publication simply means communicating the statement to a third person, to somebody other than the plaintiff, other than the person whose reputation is at stake. Write a letter to somebody in which you defame Arnold Dorsey. Well, it's then been published. It doesn't have to be published in a newspaper, broadcast on television, or on radio, or on the internet. It simply has to be published. But there's an issue even with regard to publication. For example, assume that newspaper runs a story that says Smith, the next door neighbor, says Jones committed murder. And that is exactly what Smith said. The newspaper got the quote right. Is the newspaper off the hook? No. What the newspaper has done is republish somebody else's libel. They have published the libel, even though what they are publishing is somebody else's words, not their own. And the fact that you got the quote exactly right, I mean, this alarms some journalists. The fact that you got the quote exactly right is not a defense, because you have republished what somebody else said.
So are the newspapers responsible for publishing something that they wrote, or was this going to be?
Well, the person whose reputation has been injured can and probably will sue both the person who's quoted, who libeled the person directly, and the newspaper, the deep pocket, who has republished the libel. Yeah.
How does that play into the internet? Because YouTube doesn't hold itself responsible for things that people upload and videos, things that they say in videos.
That's right, YouTube and the internet, and that's a hot topic these days. There is a provision of what's called the Communications Decency Act of 1996, Section 230 of the Communications Decency Act, that basically provides that a service provider, an internet operation that publishes, puts up on the internet, content provided by someone else, not the company itself, it cannot be sued for anything that's in that content. So that takes care of to a very substantial degree, takes care of the problem on the internet. But that's only on the internet. It's not newspapers and television and radio and so on. Well, in an ordinary case, and certainly in the case of Dorsey, there was publication by the National Enquirer. So that element of the tort was satisfied. And then secondly, in order for there to be a libel, the statement has to be false. That's part of the definition, again, of libel, a false and unprivileged statement. So falsity is now required in order for somebody to win a case. That has not always been the situation. And there's a little bit of history that you ought to be aware of. Back when we were colonies and before in England, the tort of libel meant that somebody had defamed you, and it didn't matter whether it was true. True or false, defaming somebody gave rise to a right to sue for damages. And in the famous case of John Peter Zenger in the York colony in 1735, where he was tried for libel, then treated as a criminal, tried for criminal libel for defaming the colonial governor of New York, his defense was that what he had said about the governor was true. But the judge instructed the jury, accurately on what the law was at the time, that truth is not a defense. In fact, the judge said, the greater the truth, the greater the libel. It hurt even more, because it was true. That was 1735. Between 1735 and sometime around the First Amendment, maybe a decade or two later, the common law had evolved to the point that truth was recognized as a defense to libel. If it could be shown that the statement was true, then there was no liability for libel. And thus was born the phrase, truth's a defense, which comes trippingly off the tongue even today. Truth is a defense. Yes, and that was true at common law. But the problem was, it was a defense, putting the burden of proof of the truth on the publisher. So the publisher gets sued for libel, and the person who's suing alleges that this statement about him was false and defamatory. But he didn't have to prove falsity. The publisher had to prove truth in order for the publisher not to have to pay damages. The burden of proof of the truth was on the defense, and that was the common law all the way up to 1964, when Sullivan changed it and shifted it. We'll talk about that on Tuesday. But from Dorsey's point of view, if we're pretending that it's 1963, pre-Sullivan, he didn't have to prove falsity. Falsity was presumed with the burden of proving truth on the defendant. If the defendant couldn't prove truth, then Dorsey would win. But it's still part of the definition of libel that the statement be false. When the smoke all clears, forget about the burden of proof. If the statement was true, then the plaintiff loses. Carl? You can still sue for emotional damages, but if the statement was true, you lose your libel case. Well, it depends on what your theory is. If it's a libel theory, defamation, you can't recover damages of any kind. No matter how badly you've been hurt, emotionally, financially, whatever, you lose if the statement's true, because falsity is part of the definition of the tort. John?
So like in Kobe Bryant, since the case was dropped, could he have,
The rape case? Yeah.
Since it got dropped, could he sue for libel? Since it never got, whether it's true or not, it never got proven true?
Well, people can always sue. It's really easy to do. The question is, can you sue successfully? Can you win? Say what?
Like based on these 5 principles here, or
Well, we'll consider them all and then come back to that. Okay, so in order for anybody to win a defamation case, the statement has to be false. Defamatory meaning, thank you, and that's what defamation is. The statement has to injure or tend to injure somebody in their reputation. In the archaic words of the common law, as repeated in the California Civil Code, libel is a statement that exposes any person to hatred, contempt, ridicule, or obloquy, or causes them to be shunned or avoided, or has a tendency to injure him in his occupation. Well, not every false statement is defamatory. I mean, there's zillions of them. For example, Turner is a registered Republican. It's not true. Does it defame me? No. Not in general. To be labeled a Republican does not subject you to hatred, contempt, ridicule, obloquy, and all of that. Maybe in certain circles or for certain purposes. If, for example, I was running for a public office on a partisan basis, and I say, oh, you're in the wrong party, that may have something to do with it. But generally, you wouldn't be subjected to all of that injury just by being called a Republican. How about Turner's a communist? Is that defamatory? Certainly used to be, up through the 50s when it was considered defamatory per se. Defamatory on its face to be called a communist. These days, probably not. Hard to tell. Defamatory meaning can change with the time. Turner is gay. Does that defame me? Probably not these days, although within living memory it certainly did. It certainly was defamatory. The statement that Dorsey has AIDS, I mean, right-thinking people would not, hate him for that, hold him in contempt, ridicule, obloquy, and so on. But it's not just right-thinking people who count. I mean, there may be people who will shun or avoid somebody who is known to have AIDS. So the statement that Dorsey has AIDS would be considered legally defamatory.
there would be a question of context, obviously.
Say again?
Would be a question of context.
Context, yeah, in many situations, sure.
There are, I think there are instances where, there would be all communists with possible and
Yeah.
doesn't matter, but
So, like, where would it, for example? Shunned or avoided or hated, or yeah, could be. Tendency to injure you in your occupation, that's a very common one. For example, Turner is a plagiarist. Does that defame me? You bet. If you want to be known as a publisher, a writer, something like that. Turner's a member of the Hells Angels. Does that defame me? What? Right. I got friends who are going to break your face if you don't do what I want to do. Yeah, I mean, there have been a couple of Hells Angels cases like that. And again, I think it's largely contextual. Who's the audience for this, and who you are, and what difference it might make. And it's generally a question for the judge, for the court, to decide, in the first instance, whether the statement, linguistically, whether the statement is susceptible to a defamatory meaning. And if the judge decides that it's not, this can't legally be considered defamatory, like Turner's a Republican, then the case is tossed. There's no need for a trial, because the judge has determined, as a matter of law, that the statement doesn't have defamatory meaning. And all of the elements of the tort have to be satisfied for somebody to win. So that if it doesn't have defamatory meaning, then there's no more case. If the judge is unsure, well, maybe. Depends on the context. Maybe this, in some segments of the community, this would be considered defamatory. Then the judge will leave it to the jury to decide whether, in fact, it was considered to be defamatory in this time, place, and in this community. Then the sort of obvious thing, but not completely free from subtleties, is that the statement has to be of and concerning the plaintiff. That is, about the plaintiff. The plaintiff has to be identifiable in the context. Can't be about somebody else, or your mother, or some relative, or your friend. It has to be about you in order to sue. So if somebody says that Mark Zuckerberg committed fraud in the financing of Facebook and basically is a crook, that's of and concerning Mark Zuckerberg. He could sue for libel. But Facebook couldn't, because it's not of and concerning Facebook, it's of and concerning Zuckerberg. And even though they're closely connected in the public mind, they are independent persons. Remember, the corporation is a person. Then a person for many, because this didn't start with Citizens United. Corporation is a legal person that can sue and be sued. If the statement were flipped and said Facebook committed fraud, fleeced all these investors and so on, does that defame Zuckerberg? No. It has to be about him, of and concerning him. And there's some problems with what's called group libel that come up with of and concerning. If it's a large group of people, the courts have determined nobody in the group can sue for libel. If the statement is the students in Media Studies 104A cheated on their midterm, can each of you sue for libel? No, it's not going to be considered of and concerning each and every one of you. You're too big a group.
How clear does of and concerning have to be? Like, is it up to like a highly ranked administrator at this high school?
Somebody has to be reasonably identifiable, so that a reasonable reader can put 2 and 2 together and say, ah, that's about him.
Okay, so even if the name is used.
Right? The name doesn't have to be used if the person is identifiable. You have it.
So an organization cannot sue for libel?
No,
It has to be individual?
no. An organization can sue for libel for defamation. It's usually called trade libel. A corporation can sue for libel. Yeah, Scientology was a big player in the libel business. It still is. They used to sue everybody who said anything uncomplimentary about them for libel. Incredibly expensive to write about Scientology, right? Good point. No class actions in libel. That's the group libel problem. It has to be about each individual who sues, and class actions are not allowed in libel. Part of the reason for that is that the courts, there's really 2 reasons. The courts are highly skeptical that there's any real damage to every individual in a large group. Probably not every individual was in fact harmed by this. And the second is the floodgates thing. If every individual in a large group can sue, the courts are going to be inundated with lawsuits based on a single statement. And then the statement has to be unprivileged as part of one of the elements of the tort, spelled out in the California statute and was certainly true at common law. However, there are lots of privileges in the law. Some of them are evidentiary privileges, like attorney-client privilege, where the communications between attorney and client are privileged, they're confidential. The government can't force the disclosure of what's said there. Husband and wife, priest and penitent, doctor and patient, a lot of privileges in the law. That's not what we're talking about here. In the libel context, in the tort context, something that is privileged can't be sued about at all. And there are a couple of privileges that come up with some frequency in libel cases. One of them is fair comment, which protects the expression of opinion as opposed to fact. The expression of opinion, honestly held opinion, about a matter of public concern. If it's that, reading those 3 elements, opinion, honestly held about a matter of public concern, then it falls within the fair comment privilege, which grew up at common law in the 19th century, and the first cases involved book reviews, where somebody would review a book and say, this is trash. This author doesn't know what she's talking about. She made so many mistakes that they can't even count. And the courts said that kind of expression of opinion, if honestly held, is about a matter of public concern, whether this book is something that people ought to go out and buy. That's fair comment, and therefore can't be sued about in a libel case. And so fair comment protects reviewers, editorials, expressions of opinion, and so on. Restaurant reviews have frequently been the subject of libel cases where somebody ruins somebody's business. A reviewer ruins somebody's business by saying the food is inedible, awful, the service was horrible. Don't go there. Ruins the business, but it's fair comment. Yeah.
What if the statement made is defamatory, however business goes up?
Say it again?
The statement made is defamatory, like it does tarnish somebody's reputation, however business goes up as a result of
It's hard to imagine that happening, that a defamatory statement improves somebody's business. But if there's no harm, there's no foul.
their reputation was tarnished, but they're kind of
What are they going to have in the way of provable damages?
just the fact that, could you still not sue because
They should send them a letter thanking them for the favor they've done, not sue them for libel. It's just the situation is so unlikely to show up. Yeah, would you?
do all that, that would be like someone gets hurt, for the record, they'll go up. Someone goes to hurt, bad reputation. I don't think it's that frequent. It's like a celebrity like Kardashian or something says, Kim Kardashian has a huge drug problem, so now people want to see her, so they watch her show and
That's real interesting. I'm not sure. I just, suing for libel is not a walk in the park. When you bring a suit for libel, I used to tell people who wanted to bring libel suits, you put your whole life on the line. Your whole life is open for scrutiny. Everything you've ever done, people you've associated with, things you've written, places you've been, it's all open to inquiry, and the other side is going to examine every nook and cranny of your life. Do you really want to subject yourself to that? And in the case of celebrities, technically they might be able to win a libel suit, but is it worth the agony of bringing the suit? And I would suggest that in Kardashian's case and other ones like that, where